Welcome to this video on Chapter 4, Intellectual Property, from the text Ethics for the Information Age by Michael J. Quinn. In this video, we will explore the concept of intellectual property, covering rights, protection methods, fair use, and the specific challenges posed by digital technologies and software. The rise of digital music and the internet created a crisis for intellectual property, because creating a first copy is costly, but duplicates cost almost nothing. The internet allows for rapid, widespread illegal copying, raising fundamental questions about how to manage these assets. Intellectual property is any unique product of the human intellect with commercial value, such as songs, inventions, or software. It is important to distinguish the idea itself from its physical manifestation, like a piece of paper. John Locke's The Second Treatise of Government forms a basis for property rights, arguing that individuals have a right to their own person and labor, and to the things they remove from nature through that labor, provided others have plenty left. The argument for intellectual property suggests that writing a play is similar to making a physical object, like a belt buckle. Just as one gathers ore to smelt and cast a buckle, an author mines language to craft a play. However, this analogy is imperfect. Every intellectual property is unique. If two people independently write the same play, they cannot both own it in the same way. Furthermore, copying is not theft, because the original owner still retains their copy. Providing intellectual property protection encourages creativity. By allowing creators to benefit from ownership of their ideas, society incentivizes speculative work and can ultimately improve the quality of life for everyone. Despite these benefits, society also gains when inventions eventually enter the public domain. Consequently, U.S. law balances these interests by granting authors and inventors exclusive rights for only a limited time. There are four primary ways to protect intellectual property: trade secrets, trademarks and service marks, patents, and copyrights. Trade secrets, such as formulas or customer lists, give a company a competitive advantage and do not expire. However, they can be compromised by leaks, and they are not suitable for all types of intellectual property. Trademarks and service marks identify the source of goods or services. These do not expire as long as they are protected from becoming common nouns, which is why companies vigorously guard their brand names. A patent is a public document providing a detailed description of an invention. It grants the owner an exclusive right to make, use, or sell the invention for 20 years, after which the idea becomes available to the public. Copyright provides owners of original works 5 core rights: reproduction, distribution, public display, performance, and the production of derivative works. This protection is a significant economic driver in industries like film and music. Finally, the concept of, quote, fair use allows for the limited reproduction of copyrighted work without permission. Courts determine this by evaluating the purpose of the use, the nature of the work, the amount copied, and the effect on the market. Digital recording technology evolved significantly. While copying from vinyl to cassette tapes resulted in poor quality with hiss and distortion, the introduction of the compact disc, or CD, changed the music industry by offering higher quality and increased profitability. However, the digital nature of CDs meant that perfect, lossless copies could be made easily. This shift forced copyright owners to implement digital rights management, or DRM, using methods like encryption and digital watermarking to protect their intellectual property. DRM faces several criticisms. Opponents argue that technological protections are inherently fragile, undermine fair use by preventing private copies, reduce market competition, and sometimes infringe on user privacy by tracking what content is viewed. Peer-to-peer networks allow computers to connect directly and access files on other hard drives. These networks facilitate data exchange by allowing users to access distributed content and support simultaneous transfers, often identifying systems with the fastest connection speeds. Napster, a peer-to-peer music network launched in 1999, became a major point of conflict. Following a successful copyright infringement lawsuit by the RIAA, Napster went offline in 2001 and eventually re-emerged in 2003 as a legal, subscription-based service. BitTorrent is another technology that speeds up downloads by breaking large files into small pieces. These pieces are downloaded from different sources simultaneously, making it a popular choice for distributing large content like movies and software. Universities often found themselves in the middle of copyright disputes due to their high-speed networks. After being pressured by the RIAA, many institutions implemented stricter policies, including banning unauthorized file sharing or partnering with legal music services. Today, legal music services provide authorized alternatives for consumers. These services may operate on a subscription model or a per-download fee structure, with Apple's iTunes leading the way in establishing this mainstream digital marketplace. Software copyright protection covers the expression of an idea, not the idea itself. Companies typically copyright the object program or executable code while treating their source code as a trade secret to prevent unauthorized replication. Common violations of software copyrights include unauthorized copying for sale, preloading software onto computers without a license, or distributing programs over the internet. To develop software safely, companies often use a, quote, clean room strategy. One team analyzes competitor software to write specifications, while a separate team, having never seen the original source, uses those specifications to build a new, compliant product. Some critics argue that current copyright laws are too harsh for the digital age and prioritize corporate profits over progress. They advocate for open-source models, suggesting that cooperation is more valuable than rigid intellectual property ownership. Open-source software licenses guarantee the freedom to modify, share, and distribute source code. It is a common misconception that open-source software must be free of cost. Rather, the focus is on the availability and freedom of the code itself. Open-source software fosters innovation by allowing the community to improve programs and release updates frequently. This shift often changes the business model from selling a product to providing value-added services like support, documentation, and installation. Many vital internet technologies are open source. Notable examples include the Bind system for DNS, the Apache web server, SendMail for email, various programming languages, and the GNU compilers for software development. The rise of open-source software, such as the Linux operating system, has significantly influenced the market. By providing competitive alternatives, it puts pressure on companies selling proprietary versions of Unix, as well as on mainstream desktop platforms, often resulting in lower overall costs for users. Despite its benefits, the open-source movement faces criticism. Detractors argue that without a critical mass of developers, quality may suffer, and the lack of a central owner can lead to incompatible versions. Furthermore, some suggest it struggles to provide a strong user interface or a robust mechanism to stimulate major commercial innovation. We must also consider the legitimacy of intellectual property protection for software. While software licenses are legally binding agreements that restrict copying, the broader ethical question remains. Should society provide this level of protection, and how can we justify it through utilitarian analysis? A utilitarian analysis explores whether protecting software benefits society. The argument against copying claims it reduces incentives for makers, leading to less innovation. However, this is debated. Many argue that not all users can afford software anyway, and that open-source contributors and hardware companies continue to stimulate the industry.